Hi, I'm Ishan Gambhir, and today we are unpacking a significant Supreme Court ruling that sharpens the legal boundaries of attachment before judgment and the protection of third party rights. First glance, this case appears to deal with a simple dispute over property, but at its core, it raises a far more fundamental question. What exactly can a court order to be attached before passing a judgment, and against whom? To answer this, the Supreme Court takes us deep into the statutory framework of the Code of Civil Procedure, revisits the complete scheme governing the attachment before judgment under Order 38, and particularly Rules 5 to 10, and clarifies that this mechanism is not punitive but purely protective in nature. Its purpose is limited to secure a potential decree by preventing a defendant from frustrating the execution during the pendency of a suit. The court emphasizes that such a attachment can only operate against the property that belongs to the defendant at the time of the institution of the suit. It is not a tool to reach backward and unsettle a complete transaction. Now, let's set a stage. The year is 2002. A man named V. Ramananda Prabhu, the debtor, the defendant number 3, owes someone called L.K. Prabhu, the buyer, a sum of rupees 17 lakhs. To secure this debt, they enter into an agreement. If Ramananda doesn't pay within 3 years, he will sell his property, a 5 cent plot with a building in Ernakulam, to L.K. Prabhu for 45 lakh rupees. Fast forward to June 2004, Ramananda hasn't repaid. So, on 28th June 2004, a registered sale deed is executed. L.K. Prabhu becomes the lawful owner. He takes a possession. The property starts functioning as 9 guest houses recognized by Tourism Department. Then 6 months later, a creditor by the name of K.T. Mathew enters the picture. He files a suit in December 2004 to recover nearly 44 lakh rupees from Ramananda and others. Along with his suit, he also files an application claiming that this property belongs to L.K. Prabhu. The court allows the application and the said property is attached before passing a judgment. In February of 2005, L.K. Prabhu becomes aware about this attachment sometime in the year 2007. When he does, he files a claim petition to get the attachment lifted. That is where the legal battle truly begins. The judgment also highlights an equally important procedure safeguard. With the 1976 amendment, the law expanded the scope of adjudication under Order 21 Rule 58, allowing the courts to decide the question of title and interest with the execution or claim of the proceedings themselves. And through Order 38 Rule 8, this extended framework applies even to the attachment before judgment. Attachment of before judgment remains a protective interim measure. It does not create any ownership, does not confer any rights on the plaintiff, and most importantly, does not override the pre-existing rights of third party. Now proceeding on to the legal battlefield. The trial court dismisses L.K. Prabhu's claim. It calls sale deed a fraudulent transaction under Section 53 of Transfer of Property Act, essentially saying that the sale was a sham designed to defeat the creditors. The High Court of Kerala largely agrees. But L.K. Prabhu, now represented by his legal heir after the death, takes the fight to Supreme Court. And the Supreme Court frames the real question. Can an attachment before judgment under Order 38 Rule 5 of CPC can be extended to the property that was already transferred before the suit was even filed? The appellant's argument is elegant and powerful. Under Order 38 Rule 5, the entire purpose of attachment before judgment is to prevent the defendant from disposing of the property during the pendency of a suit. If the property is already gone before the suit is filed, the provision simply does not apply. The property isn't defendant's anymore, so there is nothing to secure. The respondent, Kathy Matthew, fires back. It says the courts have the power to look into whether a transaction is fraudulent under Section 53 of the Transfer of Property Act. Within the claim proceedings themselves, especially after the 1976 amendment to Order 21 Rule 58, which expanded the scope of adjudication in execution proceedings. And this brings us to the central legal pivot of the case. If a property has already been transferred before the suit is filed, can it still be attached on the allegation that the transfer was meant to defeat the creditors? The Supreme Court answers, and the answer is clear no. If a fraud is alleged, the law provides a separate substantive remedy, but the attachment before judgment cannot be stretched beyond its defined statutory limits. The Supreme Court's reason. The Supreme Court, speaking through Justice R. Mahadevan and Justice B. R. Nagarthana, concurring methodologically, dismantles the law court's reasoning. First, the court reaffirms a fundamental principle. An attachment before judgment can only operate against the property that belongs to the defendant on the date on which the suit is instituted. If the property has already been transferred, the condition precedent to invoking the Order 38 Rule 5 does not simply exist. Second, and this is crucial, the court clarifies that if a creditor believes that the transfer was fraudulent, a remedy is to file a suit under Section 53 of the Transfer of Property Act. That is the proper forum for such an allegation. The claim petition under Order 8 of Rule 38 is a procedural protective mechanism and it cannot be stretched into a full blown trial. Third, the court emphasizes suspicion is not proof. The creditor pointed out to community ties, financial difficulties, and partial cash consideration as red flags. The court says those may raise an eyebrow, but they do not establish fraudulent intent. There was a pre existing agreement from 2002, documentary evidence of payment, a registered deed, and actual possession. Past liability, that is 17 lakh rupees already owed, is a valid consideration under the provisions of Contract Act. The court also places reliance upon its earlier precedents, which together stand for this principle. An attaching creditor cannot acquire the rights higher than those of the judgment debtor. The creditor steps into the shoes of the debtor. If those shoes are already encumbered by a prior sale, then the creditor is bound by it. The verdict and its implications. The Supreme Court allows the appeal. It sets aside both the trial court and the high court orders. The sale deed of 2004 is held valid. The attachment is declared illegal and untenable. Now, why does this matter beyond the case? For property buyers, if you purchase a property through a registered sale deed for consideration and in good faith, you are protected. A subsequent creditor of your seller cannot reach back and attach the property simply by alleging that there was a fraud. They need to file a suit and prove it. For creditors and banks, if you suspect a debtor has transferred a property to defeat your claim, your remedy is dedicated under Section 53 and not through attachment proceedings. For litigators, the court has drawn a clear line between the procedural mechanism of Order 38 Rule 8 read with Order 21 Rule 58 and substantive remedy under Section 53 of the Transfer of Property Act. And the two is now expressly disproved. Closing takes. To summarize the key takes away from the LK Prabhu versus KT Mathew. Attachment before judgment. It cannot extend to the property already transferred before the suit is filed. Second, to challenge such a transfer as fraudulent, the creditor must file a suit under Section 53 of the Transfer of Property Act. 3. Bona fide purchases for consideration are explicitly protected. Suspicion without evidence is not enough to unravel a registered sale deed. Fourth, the educatory mechanism under Order 21 Rule 58 cannot be converted into a Section 53 fraud trial. This is a judgment that reinforces the sanity of registered transaction and keeps the remedy of creditors and purchasers in their proper channel. That's it for today. Thank you for tuning in to the podcast Bites by India Law LLP. I am Ishan Gambhir and look forward to bringing you more insights on important landmark judgments and involving judicial pronouncement shaping our legal landscape. Until next time, stay sharp, stay informed, and stay curious.